Just taking a look at the ongoing hearing, and it's expected to last through Thursday. Neil Gorsuch appearing before the Senate committee, which is going to make a recommendation on his confirmation as the next Supreme Court justice. That's a prediction. I don't know if that's reality, but that's likely the direction it happens to be going. And joining us in studio this morning, in fact, speaking of the law, we have our Twin Falls County Prosecutor Grant Loebs. I've got a quick question for you right off the top. Yesterday, during some of the conversation or testimony, Dianne Feinstein from California went off on an old story about a fellow who was supposed to stay with his truck on a cold night when the truck broke down, and then he left instead to stay warm, lost his job, and she said Neil Gorsuch, as a judge, sided with the company policy, as if somehow when you take the law into account, instead of just looking what the law says, you're supposed to protect the little guy, and the law protects the big guys too as well. And I didn't understand what she was trying to do in that situation.
Well, I didn't hear the conversation, but, the law isn't supposed to look at whether you're the big guy or the little guy unless the statute takes that into account.
Mm-hmm.
A judge isn't supposed to, put his finger on the scale for the little guy because he feels sorry for him. And, I think judges, like the rest of us, do occasionally feel sorry for somebody um, who does something wrong or who is on the wrong end of a lawsuit and who seems to have sympathetic or tragic circumstances, but you can't let that be the basis of your ruling, obviously.
He has to rule on what the law said.
Ideally, there's a lot of times when that doesn't happen, though, and I think that at least he's trying to stress that he reads the law as written, reads the Constitution as written, and obviously in my job, I have to do that. But you do try to temper um, how you apply the law and take individual circumstances into account. And judges do that. For instance, in sentencing. I mean, a person with a tragic story who found themselves caught up in unfortunate circumstances and did something wrong is going to get a lighter sentence and more sympathy than somebody who, deliberately went out to do something to hurt somebody. But that doesn't mean they're necessarily not guilty. It just means you take that into account when there's discretion involved.
You think about the biblical history. King Solomon could make a decision based on just his wisdom, and he was a divine right monarch. He didn't have a constitution or a set of laws that he was making those on. We seem to be living through a period because we have a judge. And I know you're not going to comment on the specific case, but the judge involved in this case in Dietrich, and the grief he's taken from some members of the public. The fact of the matter is, he was trying to follow the law and what little evidence they actually had, and so he makes a decision, and yet it seems that every time in this day and age a judge makes a decision that isn't always popular, there is an effort to try to besmirch the judge or remove the judge, even though he was working within the confines of the law, and which is he's instructed to do.
Well, true, and the thing is that the public doesn't always know all the facts. In some of these cases, especially as we've talked about in this show before, in juvenile cases, the facts are almost entirely and deliberately kept from the public. And in complex cases, even involving adults, the amount of information that the public gets is a trickle compared to what the police have, what the prosecutors get, and ideally what they're able to tell the judge, especially by the time the case gets to sentencing. So, um, I don't necessarily blame people for reaching the wrong conclusion when they have a very little bit of evidence. And those of us in jobs like mine and like Judge Stoker's job um, also need to be aware of the fact that the public doesn't know what we know. And sometimes we can explain it and sometimes we can't. Um, but it is frustrating especially when you see, the flames being fanned in the media and, blogs and, letters and calls that come in and people are upset and sometimes even threatening, and you know that they don't know what happened. And so you sympathize with them on the one hand because if what they know is true, then they have a right to be angry. But if they had only known what you know, then they would probably understand.
And I spent about 3 years of my life just as a dedicated, I had a beat where I covered criminal courts, not only on county and state level, but in federal court. And I covered the case of Robert Morris, who was the Cornell University student who took down the Defense Department network in the late 1980s. I would come out of there, and you realize that with the technical jargon that was thrown around in that federal courtroom, we're told as a reporter to bring it down to a conversational
Hmm.
level. So people were getting that mainly, and a little bit on the process, and but a lot more on the drama. And there was just simply no way in the time limits I had and the space constraints I could give them exactly what. Unless you're sitting in that courtroom, you don't see that.
Right. Well, it's a challenge for reporters too. I mean, a legitimate, conscientious reporter has a tough time boiling something as complex as a criminal case down into, 2, 3 column inches on the front page with a jump to page 5. Um, uh, Interesting kind of story that's a little relevant to that. I had a one of the local media figures into my office to talk to me about some matters, and I happened to have on my table a pile, foot and a half high of papers, which were the papers I had to read for an upcoming case, 2,500 pages, and it's kind of dramatic when you see that. And he said, "Well, that's 2,500 pages that the public's not going to see, that the reporter's not going to see, that I'm going to read, that one other person in my office is going to read. The defense attorneys probably will read most of it, if not all of it, and the judge is going to get, maybe 100, 200 of those. And so it's impossible for anybody, including sometimes the judge, to know everything about a case because you know you just can't boil it down into a soundbite. And for citizens to get an accurate picture of everything is tough. And the more controversial a case gets, the more likelihood there is for misunderstanding. And I know some of the things about that case in Dietrich, and um, I don't think anybody, judge, prosecutor, defense attorney, anybody in that case thinks that what happened was a good thing. But it's the job of the prosecutors and the judge to apply the law to the facts. And you have to know the facts to do that for sure. But you also have to make sure that you don't, apply facts that aren't there, and assume things that you can't prove. And that's the problem with cases like that.
Our guest at the studio, Grant Loebs. He's the Twin Falls County prosecuting attorney. We're at 48. It's 9:15. Bill Colley with you as well on Top Story. And we have a caller joining us on News Radio 1310 KLIX and newsradio1310.com. Caller, you're on the air.
Well, one of the things that the public doesn't realize is that law enforcement, lawyers, and judges are bound by statute as to what that crime is or was. And certain elements of that statute have to be met before a guilty verdict or before the judges and the lawyers either come to a conclusion or it goes before the jury, and then the jury is tasked with making sure that all of the elements of the statute that deals with that crime are met before they can come back with a verdict. And oftentimes the public, something happened, probably what happened, but you can't quite, with the evidence, put the elements of that crime that are outlined in statute together to get a conclusion. And I think that's where sometimes the public, they get excited because, there are elements there that did something happen, but those elements don't quite meet the statutory requirements.
I think
Yep.
it's well said.
Yeah, the caller might be teaching a law seminar somewhere in the valley that I hadn't attended, but it's absolutely right. I mean, it's not only is it required, but it's unethical to do anything else. And I can't just I can't prosecute somebody, and a judge can't sentence somebody on a gut feeling about what they think might have happened. And I certainly can't take a case to trial on that. As the caller said, the statute will list out the exact things that we need to prove a particular crime. And if you have three out of the four, that's not good enough. You have to have all four. And if you have a gut feeling that that it really happened, but you have no witness to put on the stand to say that it did, and no evidence to put on to show the jury that it did, then what you're going to do if you take that to trial is lose. And it's not proper to do it in any case. So, um, sometimes something looks like a duck and sounds like a duck, but when you look at it, it's a chicken. And, in cases where the public gets just a little bit of information or, even a substantial part, but not all, um, they see an awful thing that's happened, and they want justice, and they want maybe even vengeance. But if they don't know all the facts, they can't they can't be in the situation that the prosecutor and the police and the judge are in, and they might not understand the statute either.
Justice also applies to the accused. I guess we have to point that out. And
Oh, absolutely. I
so
mean, my duty as a prosecutor is to be absolutely certain that the rights of the accused are upheld. Um, I can't, it's not a case where it's win at all costs, and my job is to prosecute somebody and put them in prison just because I have a feeling they're a bad guy. Um, I have to make sure that their rights are protected, as much as the victim's rights. And if I can prove everything but one thing, then I look to the next thing that I can prove. I mean, if certain crime requires you to prove four things to prove, the higher crime, and then you can only prove three, well, maybe that means that you have the next crime in line, which is kind of what happened in the Dietrich case. They had a lot of things they could prove, but they had a couple things they couldn't, and so they moved from the one charge to the next charge. And I think you've had the attorney general
right,
on
a
this
couple of
show,
weeks ago.
and he does a very eloquent job of explaining exactly the steps that they went through in that case, and he's privy to more facts about it, obviously, than I am. So uh, I can't do any better than the news reporters who just saw the parts that were in court.
We have more coming up with prosecuting attorney Grant Loebs in just a moment. We're at 48. It's 20 minutes after 9 o'clock. Bill Colley with you as well on Top Story. In fact, speaking of victims in crimes, I'm going to talk a little bit this morning, too, about the expansion, perhaps, of victims' rights in the state of Idaho. That's on the way on KLIX. We'll get to our studio guest in just a moment. Grant Loebs is the Twin Falls County prosecuting attorney. Bill Colley with you as well on Top Story on News Radio 1310 KLIX and newsradio1310.com. I do want to mention our friends at Waddell and Reed here in Twin Falls. If you're looking for someone to help you manage money, this is a great place to stop. Waddell and Reed is one of the oldest firms to offer mutual funds, owning and managing two mutual fund families, and they invest by a conservative nature. They know what they're doing, and I'll tell you why. If you want evidence of that, they've been in business now for 80 years at Waddell and Reed, and they have a planning approach, and they'll look at each puzzle of the pie when you come into the office. They try to work with your needs and goals, help build proper expectations, and Waddell and Reed helps manage money. And at Waddell and Reed, they take planning personally. There's a bill that's winding its way through the state legislature in Boise to expand victims' rights in the state of Idaho, and it sounds as if it's getting a good hearing so far, at least at this point.
Yes, it's passed the Senate committee, and it's in the House committee. I think today, in fact, maybe even right now, they're having hearings on that, and I I expect it will probably pass, and then probably pass on the floor of both houses. If it does, it calls for constitutional amendment, so it will go to the voters, at the next election. So it does. It does expand victims' rights, and it clarifies some things that are in the current constitutional amendment, because currently there is a victims' rights amendment in Idaho which grants victims a number of rights. This expands those in a few key places. It requires that victims be notified of more hearings than they're now notified of. So instead of just trials and pretrial hearings and sentencings, they have to be notified of probation hearings, post-conviction hearings. They have to be notified if the defendant or convict escapes. The kind of things that if you were a victim you'd want to know about. It requires that they have an opportunity to be heard at more hearings than they're currently heard now. Now they have a right to stand up at a sentencing hearing and make their statement. This would expand that to bond hearings, to um, plea hearings, to parole hearings, and make it more clear that they have rights to be heard at those hearings. And it attempts, and we'll see how this works with the current restitution statutes and the way that restitution is currently given, but it requires that they be given full and timely restitution for any damages that they have. So um, this is something that I think will be good. There might be some cost in it for certain people, entities, whether it's prosecutors or courts or probation and parole department, um, parole commission, in finding a way to make sure that they notify everybody. But I think that there isn't anybody who believes that victims shouldn't be notified of these things and that they shouldn't have an opportunity to be a factor in these decisions.
I was going to say it's not a deliberate attempt to get around them. It's just that the system gets very busy, and sometimes people don't get the notification.
Right, and you draw the line too, right? I mean, you don't notify everybody, and this bill draws the line too. You don't notify everybody who's guilty of a shoplifting. I mean, if somebody takes, pencils from, or magazines from the Five and Dime, that would be a huge burden if you had to notify, the victims in all cases like that. But this requires these notifications and these factors to be taken into account on felony crimes and on misdemeanors where there's physical violence. And I think that most of us think that is a reasonable thing to do. The problem is when you're in a small county, for instance, where you have few employees, or a large county where you don't have enough employees to handle the caseload. You're going to have to find the time to make sure that you have a systematic way of doing all of these notifications and making sure to meet with the victims when you should meet with them, and making sure that they are attending the hearings that they want to attend, and that they know that they have a right to speak. So it's a burden that counties, and it's going to fall mostly, I think, on prosecutors' offices, but the parole commission as well. People like anybody who is supervising any of these hearings is going to have to make sure that this is done. Um, and like you say, it's not anything anybody would want to not do. It's just a matter of, you have 700 cases a year, and you've got to make sure that you cover all those bases. And it's often not easy to get in contact with people. Sometimes, while a person's a victim, and you might be able to serve them by mail, or you might need to send an investigator out to find them. Not everybody is, available by phone or by text message.
They move sometimes.
Right, and then so there will be an increased effort needed to make sure that we, accommodate this new amendment if it passes.
I know that's been the difficulty in the past is somebody will move to Arizona, and it has been very difficult to track people down in those
Mhm.
situations. And then after the fact, they're upset that they didn't get any input into a particular hearing. This will hopefully remedy that.
Right, and I think, if there are people listening and they're saying, "Well, geez, I'm a victim and I wanna be heard," or, "If I'm ever a victim, I hope they call me." I think it's also important, to note that it's a two-way street because if a victim doesn't believe they're getting enough attention, they're not getting their questions answered, they maybe feel a little out of the loop. Um, they know who to call. I mean, they call my office or they can call the police department and they can say, "Hey, I'm a victim in this case. What's going on?" And um, that helps us, handle their case better if they take an interest and realize that we are there to help them, but we do have limited time.
We have more coming up with County Prosecuting Attorney Grant Loebs. I should make clear that's Twin Falls County. That's on the way in just a few minutes. It's 48. Bill Colley with you as well on Top Story on News Radio 1310 KLIX and newsradio1310.com. Wanted to point out our guest is in the studio with us this morning until 10 o'clock. Grant Loebs is the Twin Falls County Prosecuting Attorney. It's 49. Bill Colley with you as well on Top Story on News Radio 1310 KLIX and newsradio1310.com. Telephone number to reach our program is 736-0300, 736-0300. There was a bill that never made it out to the floor this year, and I talked to a lot of people in law enforcement that had really hoped that it would make it, and it deals with bounty hunters because, according to the law enforcers I've talked to, these bounty hunters, they're not common anymore, but there have been some cases where they've been involved. They can kick down your door without a warrant, for instance, and they don't necessarily have a lot of training. So there's some safety issues that are coming along with all of this, and yet we don't have a lot of restrictions on that in Idaho.
No, we don't. And part of the reason for that is if you think about what a bounty hunter is, a bounty hunter is a person who you have, if you're the person who has a bounty on you, you have made a contract with them. So they're not law enforcement agents in the way that, a sheriff's deputy is. They're not hired by the public. They're private. And the reason that they are after you is that you signed a contract that said, um, if you put up my bond and pay, $10,000 for me to get out of jail, I promise to come back. And if I don't come back, I agree that you can track me down wherever I am and you can kick in my door and you can drag me kicking and screaming and you can, arrest me. And then you have all kinds of other laws that intermix with that have to do with the right of people to make civilian arrests, the right of people to defend themselves, the right of people to defend themselves with deadly force if necessary. And so you add that all into the bounty hunter situation, which is a tense situation anyway. And so you have a private person who you, by virtue of your contract, have said can kick in your door and drag you kicking and screaming if you run away on your bond. And they have guns to defend themselves and they occasionally use them. And they're not required to get any training. And I think it's that last part that this bill tried to address, to require that they had some training, that they had to identify themselves more clearly, that they had to have, the absence of certain types of criminal records, and that's an attempt, and I think the sponsor said to, a step in the right direction, but um, they are not controlled in the way that police are controlled. They're not bound by, the Constitution. They don't have to respect, Fourth Amendment rights. They don't have to read you your rights when they catch you because they don't work for me. They don't work for the state of Idaho or the county of Twin Falls.
We have a caller with us. Caller, you're up next. You're on the air with Grant Loebs at 9:37. Go ahead. Well, we'll try our next line then. And you're on the air. Go ahead.
Good morning.
Good
Hello.
morning.
I have a question. I don't know that it pertains directly to anything you've talked about this morning other than victims and restitution just a few minutes ago. But my son's car was stolen out of his driveway a couple weeks ago. And then 2 days later, it was used in a home invasion over in the Eden area. He lives in Twin Falls County, so the car was stolen out of Twin Falls County, but a home invasion in Jerome or the Eden area. And fortunately, the victims of the home invasion, after the people that did this left, were able to call in a description and the license plate number of the car that they left in, and it was pulled over on the freeway, and it happened to be my son's car. So he was called by law enforcement then, I think Jerome County, and told his car has been recovered, that because it was used in another crime, it was impounded so they could get a warrant to get evidence out of the car from the home invasion. So they told him when he could come get the car, and when he did, he was charged $180 for a towing fee. And my son and his family, they live paycheck to paycheck, and it just seemed like, and I'm probably a little overly biased here, but it seemed like they were re-victimized, having to pay $180 to get their car back. Is that standard practice, or is that county by county, or is that a law? Is that a policy? What?
I would think it's more of a policy. Obviously, what happened here is that the county um, incurred a cost to recover that car. They probably used a local towing company to tow it to the impound lot, and so for some reason they're charging the owner of the car the fee to recover the car. All of that should be included in the restitution that the defendants pay if the defendants are apprehended and if they're charged and if they're convicted. Um, I don't know the exact circumstances, but if they're exactly the way you described them, I would probably go talk to the sheriff or the police department over there and say, hey, this is something that the criminal did, not my son.
We've got more coming up with Grant Loebs in just a couple of minutes. Thank you for the call. It's 9:40. It's 49 on KLIX. Our studio guest is Twin Falls County Prosecutor Grant Loebs. He's in studio with us, in fact, until 10 o'clock this morning. Bill Colley with you as well on Top Story on News Radio 1310 KLIX and newsradio1310.com. Telephone number to reach the show, 736-0300. 736-0300. We're at 50 right now. Not going to be terribly warm today compared to what we've seen recently. Just a quick note, I've been telling people over the last few months about the Total Body Transformation System, which is not a fad diet. And I'm down in the neighborhood of 70 pounds. I'll be doing a weigh-in sometime in the next couple of weeks again. The company that is behind this has an A-plus rating from the Better Business Bureau, and it's backed up by a brilliant team of researchers at universities such as Columbia, Cornell, and Tufts. I wanted to also point out you'll burn 6 times more fat and lose 8 times more weight than normal results from diet and exercise alone. The meal replacement plan often healthier than the food that you're already eating. And the cost is the same as the food that you're basically replacing. And I wanted to point out you'll be able to have a sustainable amount of calories and still eat the foods that you like. The average participant will drop 22 pounds and lose 4 inches off of waist in just 60 days, backed up with an unconditional full money-back guarantee. If you'd like to know more, contact Don Chandler right here in Twin Falls. He's at 731-3560. Don is a customer as well. He's lost over 50 pounds. Don Chandler, he's in Twin Falls, 208-731-3560. And again, do want to point out, telephone number for our program here this morning, 736-0300. We talked a little bit at the beginning of the show about Neil Gorsuch and his confirmation hearings going on. This was yesterday. This was Senator Feinstein. I've got some of her comments where she was and I think a lot of this is what you might say, just trying to ensure that her own constituents are happy. But her comments to the judge yesterday.
This is personal, but I find this originalist judicial philosophy to be really troubling. In essence, it means that judges and courts should evaluate our constitutional rights and privileges as they were understood in 1789. However, to do so would not only ignore the intent of the framers, that the Constitution would be a framework on which to build, but it severely limits the genius of what our Constitution upholds. I firmly believe the American Constitution is a living document intended to evolve as our country evolves.
So she got her statement out there, which is what she wanted to do, but it doesn't really do anything in the way of derailing the nominee.
No, she's campaigning, and so are some of the other people on both sides of that. They play to their supporters. hopefully the judge doesn't fall into that trap and play to anybody in particular. And I was listening to the quote and I didn't have it. I hadn't heard it before, and I knew exactly what she's going to say. Of course, I even wrote down some of the key words before she got to them. But what she is doing is espousing one of the two major philosophies of what the Constitution is, and she wants to make sure that everybody knows that she's a living document constitutional scholar, and that Gorsuch is an originalist, and that, there's going to be debate about that forever. There has been forever,
Mhm.
and as somebody who believes the way she believes, she's going to take issue with a lot of what he says. And I think that the misstatement there, the misunderstanding there, is to believe that because you are interpreting the original intent of the Constitution, that you're going back and using knowledge and ideas and um, beliefs and relying on facts that existed in 1789. The idea is to look at the intent and the purpose and the meaning of the concepts, not to say, well, they didn't have telephones in 1789, so this case needs to be thrown out. I mean, uh, so the proper way to look at this, I think, is to take the original intent as much as you can determine it, as much as you can find it in the actual writing, and then to make sure to take into account the fact that the world has changed and try to apply the concepts from the founders to the changing world. I mean, anything else makes no sense. And the way she said it there, it sounded, like you'd have to be very primitive to try to do that. Um, and, think like a 1789 person with 1789 knowledge. Obviously, that's not possible. But at the same time, if the Constitution's always changing and every 10 years we have a total reevaluation of what basic concepts mean, then you have no continuity.
She also wasn't done. We've got another
No, I'm sure not.
another clip from her here, and of course, I guess the cornerstone for a lot of folks in her party is a decision that was made in 1973.
President Trump repeatedly promised that his judicial nominees would be pro-life and, quote, automatically, end quote, overturn Roe v. Wade. Judge Gorsuch has not had occasion to rule directly on a case involving Roe. However, his writings do raise questions. Specifically, he wrote that he believes there are no exceptions to the principle that, quote, the intentional taking of a human life by private persons is always wrong, end quote. This language has been interpreted by both pro-life and pro-choice organizations to mean he would overturn Roe.
So these hearings would be a lot shorter if people didn't make their political statements. If they would just stick to the Q&A, I would imagine.
Well, sure, but even the Q&A, the questions are political statements. So, she's a pro-choice, very active pro-choice voice in the Senate, and to the extent that the pro-choice people believe, without really knowing for sure, that Gorsuch is a pro-life judge, they are going to fight him as hard as they can, um, and they're going to lose one way or another. Um, and as I've said on the show before, the real fight's going to come if Trump gets a second nominee.
So this is just, it's filling a seat that's not going to change the balance of the court.
Right.
But if it's Ginsburg who retires and leaves, and she was a nominee from a Democrat administration, then all of a sudden Trump's filling that slot. Then, to borrow the
You
old
change the
phrase,
balance. Yeah.
the phrase from I think Pat Moynihan, there'll be blood on the walls.
Yeah. Yeah.
Which,
No, that will be this. I don't know the extent to which the opponents of Gorsuch are going to, make this a last stand kind of thing. If they win this and get a more liberal nominee, then they don't have to worry so much about the next appointment. But as you say, this puts the court back to where it was before Scalia died, and so even if Gorsuch is a pro-life person, it's not going to change the balance on that question. You're still going to have an even split on that question, and you're going to have Roe v. Wade continue. If you add another pro-life person in a couple years, then you're going to have a big fight in the Senate for sure.
I, people have to recognize, though, the only way that Roe gets challenged is another case has to come from a lower court, generally out of a state, because if nobody does that, there's no challenge to Roe. So there has to be an attempt in a state somewhere in the country. They'd have to write a law, and it ends up going all the way to the Supreme Court, and then a new decision comes down, a little bit like Dred Scott and some of the
Mhm.
early decisions that may have been around for decades, and then they essentially were vacated because of a new decision.
True, but it's not that hard to do that. I mean, some state, if they believe that the time is right, some state will pass something that will get challenged and will go up. Um, and if the issue allows for the extension of the argument to be taken to the entire repeal of Roe v. Wade, then it can be done by a majority court.
We had in fact, a freshman state senator, and this just popped into my mind, from Lewiston, who proposed a bill like that with the whole idea that that would be one of those test
Sure.
cases that could go all the way to Washington.
Yeah, and there's no point in passing a bill like that when you know for sure that there aren't the votes on the courts to uphold it, and you know it's just going to be shot down. But in an environment where you think the court has changed, people are more likely to test that.
I wanted to get back, if we could, just quickly to, before we wrap up the program, uh, this discussion on bounty hunters. There was apparently a tragic case that happened in eastern Idaho that has rallied the sheriffs in the state around this. The impression I get is that some bounty hunters are people who were in law enforcement, and they definitely are trained and they have a pretty good head on their shoulders. The one case that was cited by the Post Register involved a guy who just started recruiting other people off the street to help him,
Right.
and that the danger comes there that one critic said it was like the lawless West all over again, that we get back
Hmm.
to that. And I didn't understand, because the sheriff's department hired a lobbyist, or departments around the state hired a lobbyist to go in there and make this point. I thought this would have been a slam dunk, and I couldn't understand why it didn't get any traction legislatively, and it didn't last year as well.
Well, there are a lot of factors at play there. There are a lot of interests that the bondsmen have in making sure that they have the ability to collect their bond money and to collect the guy who has cost them the money and bring him back so that they can get their money back. So there are a lot of financial interests involved in this. And to the extent that you go down the road of starting to make bounty hunters like law enforcement people and require that they have training and require that they have licenses and they're registered and you know, you do background checks on them. All of that that costs money and that restricts the ability of the bonds companies to have somebody go out and collect, the people who have skipped bond. So I think that's probably what the hang up is here. Um, and, I am familiar only by reading the newspapers and reading what the prosecutor in Bonneville County said about that case, which was in Idaho Falls, I think. Um, you have a guy who's skipped out on his bond. He's wanted for a felony. There's a high bond on him. And when the bounty hunters, and admittedly, they recruited people literally, I think, from almost off the street or, guys they were having a drink with the night before. But when they went to get this guy, he was armed and he was pointing guns at them and he was telling them he's not going to go peacefully. He's not going to go back to jail. You got to, if you come in and get me, if you try, I'll kill you. Well, that's a situation, of course, that police face from time to time,
Hmm.
and it's a situation where somebody's going to get hurt. So while it's bad when somebody gets shot, it's not as if this guy was putting up his hands and willing to go peacefully, and somebody just shot him. I mean, it was a complex situation, But would it have been different if the bounty hunters had been trained and had, some law enforcement experience and knew what they were doing and were, respectful of constitutional rights? Maybe. But often police are, and situations like this occur.
And bail bondsmen exist simply because a lot of people can't make bonds, so it's a loan, if you will. It's a loan that
Right,
they provide.
right.
And is, is that system a little archaic?
Uh, well, there's a right in the Constitution to have a bond, and if the only people that can make bond are the people whose parents have enough money to come in and pay to release you, then you have a situation where only rich people can get out while they're waiting trial. So the bond system is designed, to give opportunity to anybody to make a bond once the judge imposes it. And, with that come all these problems. If I'm putting up the money for you, how do I ensure I get my money back? Well, I ensure I get my money back because you promised to show up. Well, what if you don't promise? You don't fulfill your promise. Now I have to have a way to get my money back, and the court wants the person returned. And bonds people also fulfill a function for sheriffs because otherwise the sheriff has to go get you. So it's a very complex system with lots of different parts that have to work together. And this bill attempted to address a part of the system that was seemingly out of control and needed some regulation.
Are the bondsmen themselves licensed?
Yeah, I think you have to be licensed to be a bondsman, but I'm not familiar with how that works. I mean, I don't. Lots of people are bondsmen, and they're not law enforcement people, but um, they deal with a lot of money. They deal with they contract with the courts to bring people back. They contract with these individuals. It's a complex situation. And when a judge says, your bond is $10,000 and you don't have any money, um, and your parents don't have any money, and your friends don't want to put it up, um, your choice is to deal with a bondsman or, stay in jail for what could be months waiting for your trial.
Before we wrap up, for people who have a question or comment they don't want to share necessarily on the air, because I think sometimes some legal matters are a little delicate, if they'd like to call your office, how do they go about doing that?
736-4020.
I want to thank Grant Loebs for joining us this morning in the studio. We'll see you in about a month.
Okay.
And we do want to point out as well, Rush Limbaugh is coming up next following the news at 10 o'clock from Fox. And 1 o'clock, Sean Hannity. 4 o'clock, Glenn Beck. Tonight, Dave Ramsey between 7 and 10 o'clock. And Bill Colley reminding you, God willing, of the Creek Don't Rise. I'll be back here tomorrow morning between 8 and 10 o'clock on KLIX.